Welcome to the Political Bridge. I'm Ada, your host. Today we're diving into a topic that sparks strong feelings. It's about who becomes a citizen of our country. Specifically, we're talking about birthright citizenship. This idea means that anyone born in the U.S. is automatically a citizen. This is true even if their parents are not citizens. This concept comes from the 14th Amendment of our Constitution. For decades, it's been a settled part of our law, but now it's a major point of debate. Some say it's a core part of our national identity. Others argue it encourages illegal immigration. They want to change how it works. We'll explore the constitutional meaning. We'll also look at the policy choices involved. Nico and Jordan are here to help us understand. They will break down the arguments for and against changing birthright citizenship. Let's get started.
Thanks, Ada. The current interpretation of birthright citizenship is a serious problem. It creates a magnet for illegal immigration. People come here knowing their children will be citizens. This grants them access to benefits and services. It strains our schools and healthcare systems. The 14th Amendment was written after the Civil War. It was meant to grant citizenship to formerly enslaved people. It was not meant to apply to children of non-citizens. These non-citizens are not under U.S. jurisdiction. They owe allegiance to another country. We need to re-examine this. We must ensure our laws serve our national interest. Other developed nations like Australia and France have different rules. They require at least one parent to be a citizen or legal resident. This is a common sense approach. It protects our borders and our sovereignty. It's time for a policy reform. We must address this issue directly.
Nico, the idea of birthright citizenship is fundamental to who we are. It's a cornerstone of American liberty. It prevents us from having a permanent underclass of people. These people would live here but have no rights. The 14th Amendment's text is clear. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. This has been understood for over a century. The Supreme Court affirmed this in 1898. They did so in the Wong art case. Changing this would create huge problems. It would make millions of children stateless. They would be born here, but not belong anywhere. This would harm families and communities. It would also create a massive bureaucracy. This bureaucracy would track citizenship status. It would be an administrative nightmare. It's not just about policy. It's about our values. It's about treating everyone with dignity.
Both of you have laid out strong opening arguments. Nico, you've highlighted the strain on resources. You also spoke about the need for national sovereignty. Jordan, you've emphasized the constitutional foundation. You also mentioned the humanitarian concerns. My first question for both of you is this. How do you balance the legal interpretation of the 14th Amendment with the practical effects of current immigration patterns? Where do you see the most tension between these two perspectives? Nico, let's start with you.
The tension is clear, Ada. The practical effects are overwhelming our system. Our current interpretation is outdated. It doesn't fit our modern immigration challenges. The 14th Amendment was written in a different era. It didn't foresee today's global movement of people. We can't let a historical interpretation override our national security. We also can't let it override our economic stability. Legal scholars on both sides debate the subject to the jurisdiction thereof clause. Many argue it excludes those who owe allegiance to foreign powers. We need a modern, clear legal standard. This standard should reflect our current needs. It should also protect our borders. We can do this through congressional action, or we can do it through a new Supreme Court ruling. We must protect the integrity of our citizenship. This is vital for our future. We can't ignore the real-world impact. It's too important.
Nico, the practical effects you mention are often exaggerated. They are used to justify discriminatory policies. We shouldn't change our foundational law based on fear. The 14th Amendment's meaning has been settled for a long time. It's a bedrock principle. Changing it would not solve immigration issues. It would create new, worse problems. It would push more people into the shadows. It would make them more vulnerable. We need comprehensive immigration reform. This includes border security and pathways to legal status. But we don't need to strip citizenship from children. Doing so would be a radical departure. It would go against our American values. It would also be a logistical nightmare to implement. The idea of birthright citizenship is simple. It is clear. It provides stability. It also provides a clear path for integration. It's a strength, not a weakness, of our nation.
This leads us to our stress test. Nico, you argue that birthright citizenship creates a magnet for illegal immigration. However, you haven't offered much concrete evidence. You haven't shown that this is the primary driver for people coming here. Many factors influence migration. How do you isolate birthright citizenship as the main cause? Jordan, you champion the 14th Amendment as clear and settled law. Yet you haven't fully addressed the subject to the jurisdiction thereof clause. Some legal scholars argue this clause is more complex. They say it might not apply to everyone born on U.S. soil. How do you reconcile this ongoing legal debate with your claim of settled law? Nico, let's start with your stress test response.
Ada, while many factors drive immigration, the promise of birthright citizenship is a significant draw. It's a unique benefit. It's not available in most developed countries. People often make long, dangerous journeys. They do this knowing their child will be an American citizen. This opens doors to education, healthcare, and future opportunities. It's a powerful incentive. We see this in the patterns of migration. Families often have a child in the U.S., then they use that child's citizenship as a pathway. This pathway can be for themselves or for other family members. While I agree it's not the only factor, it's a major one. It's a policy lever we can adjust. We can reduce the incentive for illegal entry. We can do this by clarifying the 14th Amendment. We can make it align with its original intent. This isn't about blaming individuals. It's about fixing a broken system. It's about protecting our national interests.
Ada, the subject to the jurisdiction thereof clause, has been thoroughly examined. The Supreme Court's ruling in Wong Kim Ark in 1898 is the key. That case specifically addressed a child born in the U.S. to non-citizen parents. The court found that he was a citizen. This ruling has stood for over a century. It defines what subject to the jurisdiction means. It means not being an ambassador or an invading soldier. It means being subject to U.S. laws. This is the established legal interpretation. It's not an ongoing legal debate in the sense of unsettled law. It's a settled principle. Some scholars may offer alternative readings, but the highest court has spoken. To overturn this would be a radical judicial act. It would destabilize our legal system. It would also create immense human suffering. We must uphold the clear legal precedent. We must protect the rights of all born here.
These responses highlight the core tension. Nico, you point to the practical incentives. You believe these incentives are misaligned with national interests. Jordan, you emphasize the deep roots of this interpretation in our legal history. You also warn against the chaos of overturning it. It seems we're debating whether to prioritize perceived practical problems or established constitutional principles. This is a difficult balance. It will shape our nation's future. Let's move to our closing arguments.
To be clear, my argument isn't against immigration itself. It's about legal and orderly immigration. The current interpretation of birthright citizenship undermines this. It incentivizes illegal entry. It creates an unfair burden on taxpayers. It also creates a two-tiered system. One system is for those who follow the rules. The other is for those who do not. We need to restore common sense. We need to restore fairness to our immigration system. Clarifying the 14th Amendment is not radical. It's a necessary adjustment. It aligns us with most other developed nations. It ensures that citizenship is earned or properly conferred. It protects the integrity of our national identity. We can do this through legislation, or we can do it through a new Supreme Court ruling. This is not about being anti-immigrant. It's about being pro-rule of law. It's about protecting our country's future.
The idea of birthright citizenship is a source of strength for our nation. It's not a weakness. It prevents a permanent class of disenfranchised people. These people would live among us but have no voice. This would create instability. It would create social unrest. Our Constitution is a living document, but its core principles should not be easily cast aside, especially not for political convenience. Changing this would not solve immigration. It would only create more problems. It would make millions of children vulnerable. It would also make them stateless. We need to uphold our values. We need to uphold our legal traditions. We must find humane and practical solutions to immigration, but we must not sacrifice our foundational principles. Birthright citizenship ensures that all people born here have a fair chance. It ensures they can contribute fully to our society. This is the American way.
Jordan, while the Wong Kim Ark case is frequently cited, it's crucial to examine the specific context. The plaintiff, Wong Kim Ark, was the son of Chinese immigrants who were domiciled in the U.S. and not merely transient visitors. They were operating a business and had established residency, albeit without citizenship. The court's decision was nuanced, distinguishing his situation from children of foreign diplomats or invading force who are explicitly not subject to the jurisdiction of the U.S. This distinction is vital. Today, we face a different scenario with individuals who may cross the border solely to give birth, with no intent of establishing domicile or allegiance to the U. This wasn't the primary concern in 1898. The original intent of the 14th Amendment, primarily to grant citizenship to formerly enslaved people, is being stretched to cover situations it was never designed for, creating a loophole that undermines our immigration laws and national sovereignty. We need to interpret subject to the jurisdiction thereof in a way that reflects modern realities and protects our borders, rather than relying on a century-old case that addressed a very different set of circumstances.
Nico, your attempt to recontextualize Wong Kim Ark is a common tactic, but it fundamentally misrepresents the ruling's enduring principle. The Supreme Court's decision was broad and clear. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The court explicitly rejected attempts to differentiate based on parents' intent or status beyond the specific exceptions for diplomats and hostile forces. To suggest that domicile or intent of the parents should now be a determining factor for birthright citizenship would introduce an impossible and discriminatory standard. How would we even ascertain such intent? Would we subject new quagmire that would harm countless families and challenge the very notion of American identity?
And that brings us to the end of another insightful discussion. We've explored the complex debate around birthright citizenship. We've heard arguments rooted in constitutional interpretation and policy reform. Thank you, Nico and Jordan, for sharing your perspectives. Your insights help us all understand these critical issues better. You can find more information and resources at tpbridgepod.com. Join us next time for another engaging discussion. Until then, stay informed, stay engaged, and keep bridging those political divides.